So a very good afternoon to everyone, and a warm welcome to all of you to the second Professor C.H. Alexandrowicz Memory Lecture. I'm Khare, Research Assistant at MNLU Mumbai. We are honored to have with us Professor M. Sornarajah, sir, who will deliver a lecture on the past and present Eurocentrism, the role of C.H. Alexandrowicz in resistance and change in international law. Before we start with the lecture, I would like to invite the guest of honor, Professor Dilip, Vice Chancellor, MNLU Mumbai, for the welcome address. Over to you, sir.
Thank you, Mr. Rahman. Professor M. Sornarajah, Dr. Stellina, my colleague, Professor Anil Variath, other colleagues, Mr. Adithya, Mr. Rahman, and all other colleagues and dear participants. Indeed, it's a great pleasure to be with you, all of you, on the second Professor C.H. Alexandrowicz Memorial Lecture to be delivered by Professor M. Sornarajah. Sir, Maharashtra National Law Mumbai, which was established 6 years before, we are now in the 7th year, offering BA LLB integrated graduate course, postgraduate 1-year LLM, and other master's program, as well as diplomas. And we have 15-16 centers, and recently the new addition is Center of Research in Air and Space Law, which has been added too. As we all know that Professor Alexandrowicz has played a very great role, phenomenal role in the development of international law in India. It was in 1951, the then Vice Chancellor of the University of Madras decided to set up a new department of international and constitutional law, the first such research department in India. Professor Alexandrowicz was chosen to head it, to lead it. There he explored the history of international law in Asia and founded the Indian Yearbook of International Affairs. Over the course of a decade, Professor Alexandrowicz created a Madras School of Law, which trained leading scholars of the field in India as well as major Indian jurists and advocates. He wrote widely on Indian law and constitutionalism and acted as an honorary legal advisor to the government of India and to the then Prime Minister Pandit Jawaharlal Nehru. He was also associated with two of the authors of the Indian Constitution, Dr. B.R. Ambedkar, the chairman of the drafting committee, and Alladi Krishna Swami Iyer, and with Radha Binod Pal, the dissenting Indian judge on the Tokyo War Crimes Tribunal, all of whom were members of the Indian Committee of Comparative Law, which Professor Alexandrowicz had initiated in the year 1953. Professor Alexandrowicz contributed to the effort of promoting the idea of international rule of law by rejecting a Eurocentric history and theory of international law. There is a need to bring his scholarship to the front as an alternative to the Eurocentrism in the history of international law. I believe this lecture to be delivered by Professor Alexandrowicz, and this lecture series is our effort in this direction. For our first lecture, we had Dr. Karl, who spoke on C.H. Alexandrowicz, India, and the excavation of international law. And today, we have Professor M. Sornarajah, Emeritus Professor, Faculty of Law of the National University of Singapore, will speak to us on the past and present of Eurocentrism, the role of Professor C.H. Alexandrowicz in resistance and change in international law. Dr. Sornarajah, as we all know, who is a great scholar and legend in the field of international law. His book, The International Law on Foreign Investment, published by Cambridge University Press, is the leading one and a classic text on foreign investment law. Professor M. Sornarajah, in his article on Fighting for Global Justice, the Role of a Third World, wrote, "The life of a third world international lawyer is devoted to resistance to the norms of international law designed by the agents with power to promote the interest of the powerful sections of the international community. Quote. Every discourse requires a critical approach to its functioning, and international law should be no exception at all. The lack of local context in international law has been plaguing the culture of academic exploration and research in third world countries. Professor Sornarajah has been a voice against Eurocentrism, and we are all inspired by his vision and work. I thank Professor Sornarajah for accepting our invitation, and along with my all other colleagues and participants, looking forward to hear your great lecture, sir. Thank you so much.
Let me begin then by thanking the Vice Chancellor for inviting me to deliver this very important lecture on Alexandrowicz and his work, and particularly the Eurocentric aspects of his work, which has been an inspiration both to me and to other international lawyers of the third world. The works of Alexandrowicz must be regarded as the beginning of two important areas of international law. The first is the area of the history of international law, which, in a sense, he was the first to begin. And this aspect of his history has been covered by Dr. Landroy in a previous lecture, and in an important work by Armitage Armitage by collecting the works of Alexandrowicz. The second aspect of Alexandrowicz's work is that he initiated a very powerful anti-Eurocentric attitude in international law. It is on that second aspect that I wish to concentrate, the idea that Alexandrowicz was the forerunner of thinking that was absolutely Eurocentric. He characterized the European international law as a pseudo-universal international law, in one of his writings. So there was an absolute and utter rejection of European universal law, universal international law. Let me first outline what is known as the Alexandrowicz thesis before I start on the Eurocentric aspects of it. So I shall state what I understand to be the Alexandrowicz thesis very shortly in the half an hour speech that I was asked to make. Alexandrowicz starts with the proposition that there was a law of nations rather than an international law to start with, so that in the 16th and 17th centuries, the law that applied to the different parts of the world was the law of nations rooted in natural law, which treated all states and all kings or sovereigns as equals. This he drew upon from his extensive studies of treaty making between European states and the leaders, the sovereigns of Africa and Asia. So his studies on treaties led him to give two Hague lectures, one on the treaty making in the 16th and 17th centuries in Asia, and a second on treaty making between the European states and African sovereigns. These two Hague lectures subsequently were made into two important books published by the Oxford University Press. So his idea simply was that there was a law of nations, the attributes of which was to treat all sovereigns equally, Asian, African, and European sovereigns equally, that all states had an equal personality that was recognized by each other merely on the basis of their existence as states. This system was a horizontal system because it respected the equality of all its members, and the idea was that there was an Asian system that was distinct from the systems of Europe, which were as good and as strong as existed in Europe at that time. Alexandrowicz maintained that some of the rules of Asia were in fact borrowed by important writers like Grotius. So he traces the freedom of the seas, which Grotius had written so much about, as a principle that is to be derived from the practices that existed at the time in the maritime traffic relating to the Indian Ocean. So here was a sort of a picture that Alexandrowicz painted of a natural law-based system that was devoted to the preservation of an order based upon equality. He also analyzed the Kautilian principles that were pretty new to international lawyers of his times, to indicate that the international order or the interstate relations that existed, particularly in India and spread from India into Southeast Asia, were as powerful, as cogent as that which existed in Europe. So the thrust of that aspect of the work is to restore the prestige of Asian thinking on interstate relations and the rules that applied in interstate relations. Alexandrowicz also showed that this picture changed suddenly in the 19th century. He identifies 1815, the date of the Vienna Congress or the Concert of Europe, as a significant date at which this change took place from a natural law-based horizontal order to a vertical order that was created by the European states, in which the European states became the predominant states that articulated what should be regarded as international law. So this change then comes about between 1815 and the middle of that century, so that there is transplaced a new system based upon a positivist system, which he identified as replacing the horizontal system with a vertical system with the Europeans or the European states at the top and the Asian and the African states at the bottom. So here comes about this idea that there were superior states or states, which, as he put it in one of his articles, states without history, Geschichtlos, he says, using the German words, states without history, being the states of Asia, like India and China, or the states of Africa, which had old African kingdoms. So these states become sort of inferior states. So there is this clear distinction between the powerful states of Europe and the other states which were denied, in a sense, statehood. Because again, in this, one of the hallmarks of this system is that you find that it operates like a club, so that statehood becomes based upon the recognition by the European states. So a nation state like Japan, for example, becomes a state only when it demonstrates its ability for scientific butchery in the Russo-Japanese War of 1906. So there is a change that takes place then around the 19th century, replacing the old natural law order with a new order, a vertical order, and a feature of that order is also that it becomes an empirical order rather than an order that was based upon the doctrines of natural law, so that it became possible to argue that the customs and practices of the European states are what would constitute international law and not the practices or usages that existed in the rest of the world. So this order, of course, undergoes a change. There's decolonization, and suddenly the imperial order or the European order comes to an abrupt end with the Second World War and the process of the liberation of Africa and Asia. Here, another change takes place. And it's as if a cloud, a black cloud, has been wafted away. There is a new dawn that takes place, so to speak, or a new sun has arisen, which clears away the darkness that existed, which represented the imperial rule of the European powers. So this universal European or Eurocentric law disappears with decolonization, and new states emerge. And what's significant is that Alexandrowicz does not characterize these states as new states, but as old states, because in his thinking, what was done at decolonization was a recovery of the personality of the states that had existed prior to colonialism. So there is a sort of a new beginning, so to speak. The clouds have cleared and there is a new dawn, so to speak, which has appeared. So in that new dawn then, there was a scope in his thinking for the challenging of rules of European international order that had been made and for new states to assert themselves. So in that sense then, Alexandrowicz was a forerunner of ensuring that it was possible to redraw the map of international law to ensure that rules that are favorable to the third world states are created and that rules that are not favorable to it are displaced. So here comes about this idea that there is a huge avenue that had been created by Alexandrowicz through the breaking down of the Eurocentric order, through its characterization as a pseudo international law, and the notion that it would be possible for the new, I call them the new countries after Anand, but what he regarded as the real old countries of the world, which had been released from servitude, to restructure the European order and to make new laws that would be suitable to it. So comes about, the possibility that third world international lawyers like me and others before me and after me would be able to redraw the rules of international law, to restate them, to reshape them in ways that are more just than were perceived in the times of its drawing by the European states. So this was an immense feat for a single man to have effected. And we have to honor Alexandrowicz because of this feat that he performed, that he broke down the walls of Eurocentrism, that he liberated the lawyers of the third world to strike out on their own, to fashion rules based on justice rather than the rules based upon power. So this demonstration that Alexandrowicz made was of the historical fallacy on which European international law is based is also important. So along his in his writings, you would find references to European writers, particularly German writers and others, who try to sort of run down the effect of the civilizations of Asia and Africa. So what are truly the cradles of civilization, like China and India, are and the African kingdoms are characterized as Geschichtlos, states without history, as he points out in his in one of his writings. So what the important thing that one of the important things that that Alexandrowicz achieved was to give some credibility, not some, but great credibility to the idea that Asia did not have to conform to what was described by other international lawyers as a standard of civilization, that it had its own rules of international law, it owns its own system of interstate relationships like Rajadharma or the Kautilian principles that existed in India. The other factor is that he also demonstrated the notion of divisible sovereignty, which is important for a country like India, which consists of diverse centers of power. In that sense, then it was possible to ensure the division of sovereignty amongst component parts of a particular state. Also, he characterized the absolute illegality of colonialism, enabling India to make claims to Hyderabad, no doubt, to Goa later, and argue a case like the Rights of Passage case on the basis that the existence of colonialism was in itself a notion of aggression, that to the extent that colonialism continued, there would be a continuation of aggression, and that India would be proper in acting in self-defense to ensure that that aggression is halted by throwing out existing aggressors like Portugal from India. So these were ideas that you would find in the arguments that were made in the Rights of Passage case and are traceable eventually to Alexandrowicz. So if you look at the judgment of Moreno Quintano in the Rights of Passage case, there would be a reflection to a large extent of the ideas that had been put forward by Alexandrowicz. So these are immense plus factors that one must attribute to Alexandrowicz. And I make the statement that it would not have been possible for future third world international lawyers to follow in attacking Eurocentrism, if not for the fact that Alexandrowicz had come to Madras and worked for 11 years at the University of Madras as a professor of constitutional lawyer, producing this profusion of literature that gave a mark and a standing to future third world international lawyers. So I must salute him. But at the same time, despite the fact that this is a memorial lecture, given the fact that it is delivered in the context of a university, also make some possible criticisms or take into account criticisms that have already been made of Alexandrowicz. First, of course, his great reluctance to discuss political events, right? I mean, you see that his period, particularly in India, 1951 to 1961, was characterized by immense amount of political activity. There was the fact that the freedom movement had taken place, that the cloud of colonialism was not wafted off by wind, but by the great Gandhian movement in India, by a protracted struggle in Kenya and in Indonesia, an armed struggle had taken place. All that are not reflected. Alexandrowicz presents a picture of the return of natural law and the possibility of there being a greater justice coming about as a result of the return to natural law. And also there's the other factor that his notion of the old states being recovered. The criticism would be that the old states were not recovered in their original situation. So, for example, if you take a state like Ceylon, which he calls Sri Lanka by, because that was the old name for Ceylon. Ceylon was not one single state in its history. It was three different states. It was first ruled by the Portuguese. They had not conquered the central Candian kingdom. It was then ruled by the Dutch. They also did not control the central kingdom. It was only the English who were able to unify the whole island by controlling the central kingdom. The same analysis could be made of a country like the present Malaysia, which was not a single kingdom when the colonial powers came in. So his idea that all these states emerged in their pristine sense is not quite historically accurate, and also they are states which are fraught with a lot of internal difficulties at the moment, simply because of the fact that they were left as at the time of the ending of colonialism. Like, for example, Sri Lanka or Ceylon. The fact is that the country was handed over to the majority community without creating possible constitutional relief to the minorities. A similar analysis could be made of Sarawak and Sabah, which are attached to Peninsular Malaysia, in which the Malay community is the predominant community. So there are these criticisms that should be made. And of course, the most important thing is the criticism that there was no concern given to significant political factors that took place during the time that Alexandrowicz was in Madras, particularly the Bandung Conference. And the Bandung Conference was of great significance to Prime Minister Nehru, who played a very dominant role in the shaping of the non-aligned group using the Bandung Conference. And of course, there is the fraught relationship between the Chinese Prime Minister Chu Enlai also taking place at the same time. At the Bandung Conference, of course, it's important to note that the 5 principles of coexistence, the Panchasila doctrine, was formulated as an alternative doctrine by the countries of Africa and Asia, the newly independent countries. And this again is something that Alexandrowicz totally neglects to mention in any of his writings. And one would have thought that this was a very significant event, particularly in the life of Prime Minister Nehru, to whom, as the Vice Chancellor said, he was an advisor. The second matter, of course, is the Indochina War and the Indochina relationships that were taking place. The freedom of Tibet, he mentions in an article on the status of Tibet. He does refer to the status of China, but the Indo-Chinese border, which was again sort of a point of contention around the time that he lived in India, is not referred to in his writings to any significant extent. But the saving grace is that come the end of his life, in 1974, 1975, he comes back to reconsider this notion of the new international economic order in a very significant article in which he points out that the third world would be able to restructure the international economy using the power it has within the General Assembly. So it's very favorable to the idea of the Charter of Economic Rights and Duties of States, which forms the basic document of the new international economic order, which the developing countries were seeking at that time. But one must remember that this cry for the new international economic order, the search for the doctrine of permanent sovereignty over natural resources, had begun very much earlier in the 19 50s, from the time of independence. But at least towards the end, he does come into weigh in with his prestige to further the arguments relating to the new international economic order. So also is the fact that he makes very little reference to the other scholar in India at that time, Radha Binod Pal, mentioned by the Vice Chancellor once more. Radha Binod Pal also is a significant figure precisely at the time that, that Alexandrowicz was writing. It's not as if two ships have passed by in the night without knowing of each other's existence. As the Vice Chancellor pointed out, both men were instrumental in founding the Indian Society of Comparative Law. They knew each other. Pal was, of course, was nominated to the ICJ, the election he lost. He was on the International Law Commission, in fact, presided over some of the sessions of the International Law Commission. But there's no reference at all to him. And of course, Pal had his own distinct theory in the sense that in the Tokyo Tribunal's judgment, he had characterized what Japan was doing was criminal, but so was the acts of the European states criminal. So as far as criminality was concerned, the colonialism of the Europeans was as criminal as the idea of Japan committing aggressive war against Asia and occupying parts of China. So when one considers Alexandrowicz, it's important to give some due place to Pal as well. And we see that as much as interest in Alexandrowicz has been evoked in the writings of people like Karl Landau and David Armitage, we also find that in India, the writings of Partha Chatterjee on the Black Hole of Calcutta revives interest in Pal, and the same writer, Partha Chatterjee, also compares Alexandrowicz with Radha Binod Pal. In a sense, then, one could argue that there is a certain passivity in the Alexandrowicz view as opposed to the militancy in the Pal view. Whereas Pal was concerned with power and power politics, Alexandrowicz seems to have avoided power politics and political disputes to any significant extent. But Alexandrowicz's image has been furthered very much by Anand, who in his New States and International Law cites Alexandrowicz extensively and forgets about Radha Binod Pal altogether. But it is important to keep the other name also in considering the issues relating to the formation of or the giving of an impetus to the study of international law. That having been said, and the criticisms being laid aside, we must give credibility to great credibility to the fact that without Alexandrowicz, third world international lawyers could not have made a headway. It was he, as I said, who broke open the walls of Eurocentrism and enabled all of us to move through with whatever criticisms we have, whatever disagreements we have with Alexandrowicz. He was the man who opened the way for us and ensured that there was a regeneration of the spirit of Asia and Africa, which would lead forward a new international law through bringing about changes through resistance. And I think as far as the international law and investment, I have demonstrated that unlike Alexandrowicz, the new dawn that he talked about with natural law did not come about simply because of the fact that imperialism continued through international law. So, for example, in my field, at any rate, you do have investment treaties. I think India is at the butt end of these investment treaties with 26 different arbitrations, having to pay huge sums of money by way of damages. So there is this idea that despite the fact that there is this immense achievement of Alexandrowicz, there's also the notion that events did not move as he foretold that they would, that there would be a sort of a new dawn in which the Africans and Asians would emerge as equal nations with the Europeans. So we have to be consciously concerned with this idea that imperialism has not been wiped out, that Eurocentrism, despite this great effort on the part of Alexandrowicz to remove it, perhaps continues to this day, and that one has to forever remain vigilant. I think I have finished my 30 minutes that I was allotted. I thank you so very much for listening to me so very patiently. Thank you.
Thank you, sir. Now I would like to invite Dr. Stellina, Associate Professor, South Asian University, India, to deliver the concluding address. Over to you, ma'am.
Thank you, Aman. A warm good afternoon to all of you. First of all, let me express my heartfelt gratitude to the Maharashtra National Law University for inviting me to be part of this event. And I must say it's indeed always an honor and privilege to share the platform with the Professor Sornarajah, who is spearheading the resistance against the Eurocentric international law in his writings and teachings. I must also acknowledge that at South Asian University, where I teach, Professor Sornarajah's works and is part of the formal academic curriculum. And that actually forms a very, very formidable part of the teaching in South Asian University, whether it is international investment law or whether it is dealing with the law and justice issues. And sir, it is always a great, great pleasure in listening to you. And I should also say that at South Asian University, we make a very humble attempt at focusing on developing a South Asian perspective on international law. So hence a reference to Professor Alexandrowicz is but inevitable. So in this regard, I just want to highlight a couple of points to supplement what Professor Sornarajah has said with regard to the importance of resistance, which Professor Alexandrowicz and also Professor Anil and many other scholars has highlighted, where they're trying to bring about a third world approach to international law. So if we look into the Indian legal system or Indian academics with regard to international law, normally when we're talking about a bachelor's level, we start with celebrating the idea of universality of international law, which says that, okay, yes, irrespective of the power or the status or the size of the states, the formal equality of states. While definitely that's a matter to be celebrated, we know that in reality, there is no formal equality. The situation is far from ideal. So that is where I think the importance or the significance of that resistance to the Eurocentric approach comes, because the resistance in terms of trying to dismantle the various obstacles in the attainment of that formal equality. And one of that significant aspects in this area will be, to challenge the very dimensions of the Eurocentric approach, which is built on that international law is a product of Christian civilizations. Professor Sornarajah very beautifully captured Professor Alexandrowicz and his idea with regard to that. And Professor even R.P. Anand acknowledged that, especially if you look at that, the notion that international law is a product of a Christian European civilization, history doesn't actually support that. Professor Sornarajah has highlighted many, many examples. Even Professor R.P. Anand in his lecture highlights that, especially with the beginning of the colonialism, where as part of the nations which enjoyed a sovereignty earlier, they were subjugated or they were considered to be a kind of an inferior. So you have many examples from the history which suggest that the Asian or African nations did play a part in developing, and they did enjoy a kind of a formal relationship. But colonialism did definitely have a significant impact. So I doubt that sometimes, yes, we have given a lot of emphasis to studying the impact of colonialism on international law, but I think more has to be needed. So if you look at the work of Professor R.P. Anand or Alexandrowicz, yes, apart from this scholastic work, Professor Sornarajah has highlighted the passage from the rights of the passage over the Indian territory, where the ICJ has formally acknowledged a treaty signed between the Maratha ruler and the Portuguese. So that definitely suggests that somewhere that the Maratha rulers enjoyed some kind of an international identity. So if I look at even in the latest development, in the Gyapchikova-Nagimaris case, when Professor Veeramantri has come to the conclusion that sustainable development as part of a customary international law, he doesn't refer to the Eurocentric approach, or yes, he does not only emphasize on what happened after 1972, the Stockholm Declaration. In fact, he goes on to highlight various Oriental civilizations, the Asian and other cultural practices, and then come to the conclusion that the idea of sustainable development has always been part and parcel of this Oriental civilization, and hence it can be considered to be a customary international law. So that's definitely, I think, a very powerful acknowledgement and the notion of resistance to challenge the Eurocentric idea of international law. I should also actually recall that in my university, one of the interesting dissertation was relating to the legality of the Bahadur Shah Safar. One of the students, Mr. Aman Kumar, did that a very excellent dissertation. So wherein he challenged the legality of the trial of the Bahadur Shah Safar. So if you go by Professor R.P. Anand's or Alexandrowicz's idea that, yes, the Mughal rulers or Maratha rulers, they did enjoy a kind of the sovereignty under international law or the law of nations. So if you consider that, then definitely the legality of that trial can be questioned. So I think the obligations or responsibility of academics who are in the global south teaching international law is not to just start with a positivistic approach to international law, relying on the formal sovereign equality. I think a reference to history is important, that history should not be just confined to a footnote saying that, yes, in the development of international, the Asian or African civilization or other continents or other countries did play a part, but to give them the kind of a legitimacy in terms of the acknowledgement that, yes, it's not just confined to footnotes. Yes, they did definitely play much part into it. The second point has to be challenged is the notion of civilized nations. Even now, if you look at the Article 38 of ICJ, they use the word of general principles of law recognized by civilized nations. So it's a kind of a white man's burden to civilize the global south. And in this regard, I'll just mention an interesting case of an arbitration immediately after the call to the colonization has ended, where in that Aramco arbitration case, the House of Lords said that even though the parties to the dispute had chosen Saudi Arabian law as the applicable law, the court mentioned that it's very difficult to believe that a country like Saudi Arabia can have a very sophisticated legal systems. So I think that notion is definitely very problematic, to say that, yes, a sovereign states may not have a certain kind of an idea. So what is the threshold of having a civilized or a sophisticated legal system? That definitely has to be challenged. So I think this challenge has to come from the idea that we can't look at international law without adequate reference to history. Like, for instance, if I speak from the perspective of international environmental law, yes, comparison to many branches of international, I think this is one area where the developing South did have its voice, mainly because this is subject as a whole is believed to have begun after 1970s, when the colonialism at least formally has ended. So yes, the developing nations were able to articulate certain concessions, or not exactly concession, it's a legitimate, because when you look at it and link it from the point of view of history, a differential treatment, or the idea of fair and benefit system, or the concept of environmental justice or a climate justice, which we are talking about. But even then, when you look at it, a particular treaty, whether it is a climate change treaty or a biodiversity treaty, without having a reference to history becomes problematic. So when we say history, I think the impact of colonization on international law and continued the impact on colonization has to be understood. Like, you can't think of developing a branch of international law like economical law or IPR without having that core acknowledgement that yes, colonialism did play a very, very major part and continues to play a major part in impacting the development of international law. So I think as an academicians, as the scholars from the global South, we need to spearhead while celebrating and the Alexandrowicz work. We need to, when in our works or a teaching, the idea has to be that, yes, the history is important, and that history and its linkage with the colonization. So I think that will give us enough of a corpus to, fight against the Eurocentric idea of international law in terms of legitimacy of participation, in terms of being representation. See, the idea that if I take UNEP, it's a very strange to think that that's the first international organization to be headquartered outside the global north, and that happened only in 1972. I think these are the kind of legitimacy issues we need to challenge so that the contribution of the global South is not just confined as a footnote, but it can be taken to the center stage of international law. Thank you. Thank you so much.
Thank you, ma'am. I, on behalf of the entire family of Maharashtra National Law University, Mumbai, express a hearty vote of thanks to all the speakers of today's event. Thank you, Professor M. Sornarajah, for accepting our invitation for delivering the lecture. Thank you, Stellina, ma'am, for delivering the concluding address. I would like to take the opportunity to place on record our gratitude to Professor Dr. Dilip Ukey, sir, Vice Chancellor, MNLU Mumbai, and Professor Anil Variath, Registrar, MNLU Mumbai, for the institutional support. Special thanks to Adithya Variath for conceptualizing this event, and Manohar sir for being our hope and helping us with all the technical support. I would also like to thank our media partner, Bar and Bench, for promoting this event. We apologize to everyone for the inconvenience caused, and I thank all the participants for sparing your valuable time for joining this session. We shall be uploading the lectures video on our YouTube channel, and it shall be shared to all who have registered, and we are looking forward to have you in our upcoming lectures. Thank you everyone for joining us. It was a great time for having all of you here.
Thank you. Thank you very much.
Thank you.